topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, South Florida. Welcome to another Ask the Expert show where we bring you the finest experts in the field of legal, health, financial, and home improvement. I just read a weather report. Looks like we're going to dodge this hurricane out here in South Florida, but it looks like it's going to go over to the Gulf. So we extend our prayers out to those people. But it looks like we're going to be okay. We have got such a great show for you today. I've been doing this show it's now 13 years. We do about 50 shows a month, and this is the show right now is our number one show based on how many people contact us, our listening audience numbers. And it's just, I just want to thank everybody. You take the time to write letters in, tell us how much you're enjoying the show, give us your questions. And we are so glad that we can bring you one of the finest law firms, K. Bender Rimbaum. Answer your questions. It doesn't cost you anything. So let me welcome to our number one show, board certified attorney, Robert K.
Hello, everybody. Hello, Steve. How you doing?
Hi, Robert. I love having you on the show. People love you. This is just one of the greatest shows. I've got so many questions, Robert, for you today. And then we've also going to talk about all the free classes that K. Bender Rimbaum offers, because education is so important to your firm. Isn't that right?
It absolutely is. Yes.
And all these classes you do are all free.
They're all free.
So now we know why you've got such a successful firm. You know, Robert, we're getting new letters. People are finding the show every day. Please tell everybody about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a full-service law firm that primarily focuses on the area of community association law, condominiums, homeowner associations, cooperatives, and anything that comes up in the legal aspect of operating these communities on a day-to-day basis, be it reviewing the documents, advising the board as to rights and responsibilities, obligations, unit owner limitations, unit owner entitlements, dealing with contracts, pursuing unpaid assessment accounts, construction defect litigation, across the board, anything and everything that an association might face on a legal basis is where we focus our energies, our time, and our expertise. We have I believe 10 board certified attorneys, one of which in construction defect litigation, the rest in community association law. Out of maybe 200 in the state of Florida, we've got 10 of them within our firm. We provide this in the offices in Pompano Beach is our main office, Palm Beach Gardens, Orlando, and Tampa.
Well, I've got to tell you, I know customer service is so important to you. And, you know, if there's I guess a property out there and you're not satisfied with the law firm that's you're dealing with, give K. Bender Rimbaum a call. Sometimes when you get a second opinion, it could really help you. We've got so many questions that we're going to go to today, and I guess got a lot of new laws out there, don't we?
Well, we have a lot of new laws, but a lot of old laws as well.
Yes, that's true. We're going to go to Eileen in Boca Raton. How will it not having Kaufman language affect the association concerning the new laws?
Well, that's a very, very timely and important question as it relates primarily to homeowners associations. The new legislation that was adopted for homeowners associations has a number of provisions that are considered substantive in nature. Substantive meaning they're dealing with what is referred to as vested rights, real tangible rights that people have in their communities based upon what's set forth in their governing documents, primarily their declarations of covenants. Kaufman language is based on a case from the late 70s in which the courts ruled that in order for substantive changes in statutes to apply to existing communities with existing governing documents, there needed to be specific language contained in the documents that incorporates future amendments by stating simply as amended from time to time when it's referring to the laws that apply. Otherwise, it's the laws in effect on the date that the covenants are recorded in the public record. So if you have a homeowner association that was created in 1988 and they have a declaration of covenants and it's pretty much the same as it's always been, and there are restrictions and limitations contained in that declaration, and one of the provisions says that you can have no commercial trucks parked in the community at any time other than providing services to the property on a temporary basis. So residents aren't supposed to have commercial trucks. So the new legislation says you can't enforce such restrictions. But if you don't have the language that incorporates substantive changes into your community, then the new changes would only apply to any HOA that has a language or comes into existence from the date of the effectiveness of the statute, July 1 of this year. It's a complex legal issue that can have treatises written about it, and it's based upon the United States Constitution and Florida Constitutions, both of which state that the state is not allowed to adopt laws that conflict with vested contract rights. It's referred to as a contracts clause. So the Declaration of Covenants is a contract between the association and the homeowners. And if there's a substantive change in the statute and there is no Kaufman language, then the legal position would be that those new changes do not apply to that community. It's going to take significant litigation to get to the bottom of this, and that's going to likely take a couple of years. So based on the question, if they do not have Kaufman language in their documents, the legal position of the association could be, and often would be, that these statutory changes to their entitlement and power of the association would not apply, and the restrictions that are in place remain. That's in essence the short version of that issue, which is much more complex.
We're going to go to an HOA question, and we're getting a lot of questions, I guess, especially HOA, about the website. It says, on the website, our board has placed our documents visible to the general public and the membership. Is this wrong?
Well, there are certain aspects of official records that are not supposed to be made available to anybody. Those are set forth in the statute, and those items wouldn't be something that an association should post on the website. The documents are public record, so there's no problem in putting the documents on the website, even if it's available to the general public at large. The association could set up the website so that it has limited access to certain information to only those who have password sign-ins, which would be the membership of the association, and have other documents available to the public at large. So that would be the preferred method of setting things up. Putting all the official records on the website could create problems to the association. And before doing so, the board should consult with its association attorney to make sure that they're not inadvertently putting things on there that shouldn't be.
Here's a nice letter. This is from Kyle in Boca Raton. I just was elected to our board. I got on the board because I'm a longtime listener of your show. Thank you so much for all the great information you give us. We are an HOA. I heard HOAs are no longer allowed to fine owners. Is this true for condos?
Well, being in an HOA, it's not true that they're no longer able to fine. The legislature has created certain hurdles and additional abilities of owners to get out from under a fine by complying with the requirements of the association at certain times of the process, even after the fine has been imposed. So fining can be tricky for homeowner associations. The condominium side is a little different. In the fining procedure, it hasn't really changed. The issue there is collecting a fine, because in the Condominium Act, it's expressly stated that a fine cannot become an assessment and a lien against the unit. In the homeowners association statute, there is the ability in certain circumstances that a fine can be an assessment against the unit, but the governing documents have to have a specific authorization to turn it into an assessment. The legislature does not speak to that, but in basic property law, in order to be a charge against the property, the governing documents have to specifically state that as it relates to the fines. So the question kind of covered both condo HOA. I think I've gotten it. The HOAs can still use the fining process. It's less desirable than it used to be because it's created more obstacles to associations. The purpose of fining to begin with was to create an alternative remedy to having to go to court, which can be very time-consuming and expensive for all the parties. And it was really more to deal with minor violations that might not be recurring, and allow for enforcement in a less intrusive fashion and internally to the association. Now, sometimes things get a little out of hand, so that's something they have to keep into account. Again, with this issue, if an association is doing the fining process, it does make sense to touch base with your association attorney and make sure that your procedures aren't going to somehow create an additional enforcement problem to you with the changes that were put in place this year.
Okay, here's another HOA. If a parcel owner opts out of not using the new website, how does the board keep communication and supply notices in the future?
Generally speaking, notices still have to be provided in multiple ways. You still have to provide a posted notice somewhere. You have to provide written notice in certain circumstances, and just putting it on the website alone is generally not going to be sufficient. So sometimes owners have agreed to receive notices by email. Sometimes they have not. I think we're still in a situation where associations, even though they use email for notifications, may have to also use the mail. But that is going to depend on what notice they're sending and specifically to who.
Here's one actually to the firm. Will you offer an approved 4 hours of the newly required coursework or recommend one?
We have courses that are up for approval. The Division of Condominiums has been tasked with creating course requirements and approving courses. And we have multiple courses that are in the process or already have been approved. And in the upcoming weeks and months, we will be having more announcements of classes for that purpose. So you can watch for that on our website at kbrlegal.com. We'll be talking about it on the show as these things develop. The division, I believe last I heard, by the middle of August is supposed to have a more concrete position on the newly required educational requirements for both HOAs and condominiums, for prior boards and future boards, because the education requirement is applying to all board members, not just those that come onto the board after July of this year.
Hey, Robert, why don't you go ahead and give the classes that you've got coming up so far for August?
Okay. Thursday, August the 8th. I think, let's see, that's next Thursday, 1:30 to 2:30. There's going to be a live event going on for the full day at the Hilton at Palm Beach International Airport. Jeff Rembaum will be doing a class 1:30 to 2:30, jumping into the present importance of updating your governing documents. On Wednesday, August 14th at noon to 1 p.m., a Zoom Castles Association leadership presentation with both Michael Bender and Jeffrey Rembaum as guests of that show. On Friday, August the 16th, from 10:30 a.m. to 12:30 p.m., we have a Zoom presentation, a 2024 legal update covering the 2023 changes. This legal update goes through September, and that's how they structure it. Alan Schwartzide from the Orlando office will be instructing that. On Thursday, August 22nd, from 12 noon to 1 p.m., we have another presentation of jumping into the present, why updating the governing documents of your association is critically important. The instructor is Emily Gannon from the Pompano Beach office, and that's hosted by Trident Management. And Friday, August 23rd, 11:30 to 12:45, 11:30 a.m., 12:45 p.m., also via Zoom, navigating the Federal Fair Housing Act, assistance animal or pet. Danielle Brennan from the Palm Beach Gardens office will be discussing that issue, and that's hosted by GRS Management. Now, all of these are on our website, kbrlegal.com. Click on the calendar and choose the event you want and register for the Zoom so you can get the credentials and participate in these projects.
And we cannot just call attorney Alan Schwartzide. We now have to refer to him as board certified.
Board certified. Our newest board certified member, yes.
Yeah, I think he said he got certified about a month ago.
I think the notices went out in June.
Hey, we're going to go
I
to
can't
break.
believe it's August already.
We're going to go to break. Robert, give everybody the phone number and your website address.
You can reach us at 1-800-974-0680. You can find us at kbrlegal.com, or you can write it to us at info@kbrlegal.com. That phone number works for any of our offices.
Yes. We're going to go to break. When we come back, we'll have more with K. Bender Rimbaum, attorney Robert K. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the long-running Ask the Expert show with our long K. Bender Rimbaum Community Association law firm. This is our number one show of all the shows we do across the country. We're here with attorney Robert K. We're going to go to Sharon in Davie. She wants to know, in a request to records, does the board have to supply a parcel owner with a list of owners' email addresses?
Well, owners and addresses are a part of the official records. It's not exactly right that they have to provide a list. It has to be made available for owners to find in their record inspection. They've made it a little more involved for associations to maintain their records in a way that makes record inspections more accessible and easier for requesting owners. And it still remains, an owner doesn't have the right to simply say, give me a copy of this, give me a copy of that. They still have to do the actual inspection. But the email addresses that the association has on file for use in the notices, official notices of the association, are part of the official records that are open to the inspection and copying of the requesting owner.
Juan in Fort Lauderdale wants to know, if an insurance claim involving hurricane damage and cancellation of insurance has been settled, would the condo association be required to show the settlement documents to an owner if requested?
Yes, those types of documents are official records of the association that the statute does not include in the exceptions of what an owner has entitlement to see. Oftentimes in litigation, there's confidentiality provisions within the agreements of settlement that indicate that both parties aren't supposed to allow or share the information with anybody else. Under the law, though, that confidentiality doesn't extend to the members. They have a statutory right to see these types of documents. They're not supposed to publish them, but the association does not have the ability to control them once they have that information. It's important when these settlement agreements are entered into by associations that the attorneys are aware of this little limitation and don't put the association in a position of potentially violating that settlement agreement by an owner getting access to this information and sharing it.
Gene in Boca Raton, new laws require many documents be on the website. I have two issues. First, can an owner still request hard copies? Second, how do we stop an association from saying, well, it's on our website, you can go find it?
Well, the intent of the statutory changes is to allow associations to post the listed records on the website, and an acceptable response to a record inspection request is that it's on the website. So the only way to stop that from happening is to get with the legislature and get them to change that. But that was the way things went. The owner questioning here does, as I noted, doesn't have the right to say, give me a copy of something. You'd have to make an appointment for an on-site inspection and come in. If all the things that they're supposed to provide access to is on the website, that may not happen, and you may have to download it from there. And I know people have technological challenges and that can be difficult, but that seems to be the way that the legislation has been going.
Here's one, Kashmir, I believe it's pronounced. Are directors' emails among the board confidential, or can members request review of the emails?
I missed the first part of that. Can you repeat?
Are directors' emails among the boards confidential, or can members request review of the emails?
So I think if I'm understanding the question, they're talking about emails between board members on their personal email accounts. Would that be open to an owner's inspection and copying? Is that an official record? And it has been held that those are not part of the association records if they are the board members' personal email accounts, even when it's discussing association business. So that is something that might not be readily available to an individual on a record inspection request. That being said, if there's litigation involved, that's not beyond a subpoena in the discovery process. So you're able to get that way.
Okay. Jordan in Palm Beach, if an owner requested to see the documents that a public insurance adjuster submitted to the condominium's insurance company, would the condo association be required to comply with that request?
We have a lot of records inquiries today. This is another example of what is not considered an exception to the official records. It is part of the association official records that it should be made available to a requesting owner for inspection.
We have John in Boynton. He wants to know, well, we know that the mandatory educational bill was signed. Can you explain it?
Well, in a nutshell, there's going to be more education requirements in order to qualify to remain a board member in both condominiums and in homeowners associations. They're different in some respects based upon the number of properties within the community that is being managed by the association. You may recall that prior to these changes, there was a requirement of either education of a certified course, which is generally an hour, or sign a paper that says you've got the documents and you'll abide by them. It didn't even require you to read and understand them. With the changes in the laws, now there's going to be requirements of, I believe, 4 hours of education on an annual basis. I believe that's in the condominium version. I'm just trying, it's hard sometimes to keep them straight as I'm not dealing with these on a day-to-day basis. So in the HOAs, if you have less than 2,500 parcels in your community, it's going to be 4 hours on an annual basis. But if you have more than 2,500, then you have to do 8 hours on an annual basis.
Whoa.
So that's a lot. There's also a board member certification requirement every 4 years on the HOA side with the education. Now that's the items that the division is putting together for completion on both those HOAs and condos. That should be coming hopefully by the middle toward the end of August.
Okay. We're going to go to Jack and Delray Beach. And we get a lot of these, Robert. I bought into a community and now I'm being told there are restrictions I don't like. How was I supposed to know? We get a lot of questions like that.
Well, it's an unfortunately common occurrence, but what's supposed to happen, if you're using a title company to close your real estate transaction, the restrictions are brought to your attention by them. Typically, where you see something like this, it might be a private transaction that doesn't involve an attorney or title company helping the purchaser, and they become unaware. These restrictions are in the public record of the county that the property is located in. So even if no one tells you about them, because they're in the public record, you are considered to have knowledge of them. And so it's really incumbent upon the purchaser to ask questions and do the necessary research to find out. If you ask the question and the seller tells you there isn't any and it turns out there is, well, then you've got a fraud issue that you might be able to have some recourse on. But in the vast majority of standard real estate transactions involving title insurance and title companies and duly licensed closing people, this information is brought to the attention of the purchasing individual. But unfortunately, the onus falls on the purchaser in Florida.
So a lot of people are upset with their realtor not telling them. So it's the same thing.
Well, it isn't so much the realtor as it would be the title company. Realtors, in part of the general real estate sales contracts, there is disclosures about the various documents, or there should be. So if there isn't, that might raise a problem for the realtor.
Here's another problem that we get a lot of. This is Phil in Boynton. He said, why would our community do more construction where we have to add more money to our reserves when we are barely getting by now?
Did he say HOA or condo?
He did not say.
Well, in the condominium side, as we've known since the tragedy that occurred in Surfside a couple of years ago, there has been a lot of legislation adopted that creates additional review and reserve and maintenance obligations to all condominium associations that are 3 stories and above. And this is requiring reserves that weren't there required before, that owners were able to waive. Now they're no longer able to waive a number of these, a large number of the reserve items. There's still a couple of them that can be waived, but it's not going to affect the major financial impact that reserves are having throughout the condominium industry in Florida. A lot depends on how the buildings were maintained prior to these changes in the laws and whether or not significant issues are discovered when they do these reviews. The legislature considered it important that there be sufficient reserves in place so that these necessary repairs will be accomplished, and that's creating a lot of difficulty for the individual owners who have to foot the bill for this. It's also affecting the ability to sell condominium units, and it's, I'm sure, affecting the general market in that regard.
Here's one. I'm thinking about running for our board. What are the responsibilities of being a board member?
Generally speaking, a board member, board members are the ones who establish policies and operate the association, make the major decisions of what's necessary for the operation of the association. And then those decisions are carried out by the officers of the association, which are often the same people, but they're not necessarily the same people. And so board members set policy, make decisions, enter into contracts. Every operational aspect of the association requires a board's approval, unless they delegate it to a committee or to individual officers, depending on the situation. And then the officers will carry out those requirements. They'll sign the contracts. They'll make sure the money's collected in place, spent appropriately, whatever the issue is. Responsibilities of board members vary from community to community, depending on a wide variety of factors. You know, how big's the community, what the association does within the community, how involved it is. Is it just doing landscaping, or does it handle all operation and maintenance of all the buildings? So, you know, it could be more involved, it could be less involved, depending on where you live. It's generally been considered a recommended practice for every owner in a mandatory association community to be involved in their association at some level, at some point of their ownership. Serving on the board is one way. Participating in committees is another way, or just coming to meetings and attending and participating and being involved is I guess, the least intrusive to their daily life, but that should occur. Putting your head in the sand and ignoring the association is probably not the best approach, and it can create problems for you that you didn't expect to occur just by virtue of not being aware. And so it's really hard to give a more specific answer to this question without knowing more about them.
Craig in Pembroke Pines, HOA parking laws. Is it true one of the new laws now allows work vehicles? We got a lot of questions about this. Now allows work vehicles can now park in your own spot or driveway.
Well, that's a big issue, and that's what we touched on with the first question, with the Kaufman language, as to whether or not that statutory change will be applicable to existing communities that do not have the magic language in their documents incorporating changes to the legislation. And in the homeowner association setting, I'd say the vast majority of associations do not have that language. Generally, developers do not put that in their documents, so where they are found is often by amendment that the owners put in on their own. And I know a number of communities are sorry that they did put that in years gone by, but it used to be fairly standard when amending documents that did occur, because it was expected that changes in the legislation would be a good thing. Not everybody considers the changes that have been made in this respect a good thing. Those who have trucks and those who support those who have trucks and those who hate associations think it's a good thing. Members of boards and people who want to keep their community in accordance to the way it was intended in their documents or has evolved through the years think it's not a good thing. So perspective is certainly important on the topic. The law says that the association cannot enforce it. Whether the law is applicable is the open question that it's going to take a court to reach a final decision. Whether or not the case actually gets to court is another story, because people have to be willing to commit to that lengthy, expensive prospect.
You got a couple more minutes left. This will be the last question of the night. Mary in Fort Lauderdale, my condo association used reserve funds to settle litigation settlement problems. Can they do that?
They can only do that if they had a vote of the owners to use the reserve funds for purposes other than what they were being held. And we're not talking about the new restricted reserves that can't be waived. And those haven't kicked in yet. So chances are in this particular question, she's not talking about that. If the board used reserve funds without a vote of the owners, they're in violation of the statute and can be subject to fining by the Division of Condominium if a complaint is filed there for the misuse of reserve funds. A method of resolution which does not eliminate the fact that they're in violation of the statute would be a special assessment, considering it as a budgetary shortfall. Their operating funds are in the negative, not the reserves, and they need to replenish them with a special assessment. It's a matter of bookkeeping and semantics quite often. Reserve funds are not supposed to be used for anything other than what they're being reserved for, unless the owners vote to do so.
Well, Robert, that's going to wrap it up for us tonight. Robert's with us the first Thursday of the month at 5 o'clock Eastern Time. He gives up his first Thursday of each month as a free service to our listeners and viewers. Robert, you're amazing. I'm glad you're okay.
Thank you.
Robert had an auto accident this week. I'm glad you're fine.
Well, that's a week ago today. I'm happy to be standing up.
Yeah. Anyhow, we'll see you again next month. Robert, thank you so much.
Thank you. Everybody have a good month.
For sure. That's attorney Robert K. Bender-Rimbaum, one of the finest HOA community association law firms in the state of Florida. That's it for us. We're going to be back with you again next Thursday with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.